Hey, what's up? It's Julie. I'm a lawyer and a former top law student and lecturer in communication studies. And today we're going to be looking at covenants. Covenants are rules that apply to land and they affect how land can be used. Covenants operate in equity, which means you can't officially change a title to say that it has a covenant, but you can add a note to the title saying there is an equitable covenant on this title. And because they operate in equity, that generally means a purchaser will need notice before it is binding on them. Okay, so the thing that really gets people with covenants is there are all these tests about whether they stick to the land if you're selling it or if you're passing on your lease to someone else. Covenants are these rules, they apply to land. And the question is, if you're selling your land or if you're passing on your lease, does that covenant still apply? That's the question that stumps everyone. In New Zealand, there are two different tests you have to look at in regards to whether the covenant will pass on with the land. The first one is if it's leased land, there's a separate test for that. And the second one is if it's not leased land, there's a whole nother test for that. So the test for whether a covenant runs with the land for leased land, and that means whether you have a piece of land and you have a lease on that piece of land and you want to pass that lease on to someone else, does the covenant or the rule that applies to that piece of land pass on to the next person who's going to lease the land? So the test is in section 231 of the Property Law Act. The covenant does pass with the land to the next lessor if the lease came into operation after the 1st of January 2008, no matter what. So if you have an exam question and there's a lease that was created in 2009 and you're trying to pass, your client's trying to pass that lease on to someone else, yes, you don't need to look any further. It's after 2008. So yes, covenants always apply. Covenants always pass with the land after 2008, January 1st. If the lease comes into operation before the 1st of January 2008, the test is yes, the covenant runs with the land from one lessor to the next if the subject matter of the lease touches and concerns the land. So what we're thinking with touching and concerning the land, it has to relate to the land itself. So what that means is if there was a covenant on a piece of land saying every week you have to come and, if you're leasing this land, you have to come and give a massage to the owner of the land. It's not really related to the land itself. It's related to sort of a personal obligation you have. But if something is like, if you're leasing this property, you can't paint the walls white, or you have to mow the lawns in a particular way, it's all related to the physical land. So that is all touching and concerning the land. So that covenant would pass from one lessor to the next. So the case P&A Swift from 1988 found that paying rent was a covenant that touched and concerned the land. In relation to non-leased land, so if you're buying a piece of land and there's a covenant on that piece of land, does it pass on to you? So the test for that is held in section 303 of the Property Law Act. And the test is a little long. So yes, the covenant passes from one owner of land to the next owner if the covenant is intended to run with the land. So again, thinking land, what's actually related to the land and not just a personal obligation. 2, if it is restrictive. So that means you can't do something. So if the covenant is stopping you from doing an action or, preventing you from building a second story, preventing you from changing the building in a certain way based on heritage laws. So if it's restricting you in some way, then yes. Or if it is a positive covenant, which means it's making you do something. So the little catchphrase is if you have to put your hand in your pocket and actually do something to fulfill the covenant. So maybe you have to mow the lawns every week or something like that. then yes, this covenant can pass with the land if it came into operation after the 1st of January 1987. Number 4, there is no privity of estate. So that means the person who's creating the covenant and the person who's being burdened by the covenant, so the covenantor and the covenantee, they're not the same person, or they're not in a rental agreement with each other. Next, it has to burden the land. So someone's land, remember land, something physical, has to actually be burdened by the covenant. It can't burden Julie personally, it has to burden the land. In the Cedar Dry Cleaners case from 1988, this is relating to an outside shopping mall area, and there was a covenant which made the owners of those shops pay a levy to the managers of that area, and the levy was to keep up the appearance of the outdoor shopping mall, so mowing the lawns, keeping the whole appearance nice. So the owners of this dry cleaners, I believe, were trying to say, no, we shouldn't be bound by this covenant because it's not related to land. Paying a levy is not burdening my land, it's a personal obligation. And the courts actually said, no, this does burden the land because it is, if you don't pay the levy, the land itself will look ugly. It won't be maintained properly. So the court said, yes, this is actually related to land. Number 6, it has to benefit someone else's land. It can't be related to something not to do with someone else's land. So for example, if there's a covenant to not build a second story on your land, which is probably quite a common one, it does benefit other people's lands because it might preserve their view or their sunlight. If a covenant stops similar business activity from taking place on neighboring land, that is considered a benefit to the land. So that comes from Half Moon Bay 2002. 7, the other party has notice before purchasing. Because remember, we're dealing with equity, and there's the whole equities darling, a bona fide purchaser for value without notice. What a mouthful. So if you don't have notice, then it won't be binding on you. However, if you notate your title following the steps in section 307 of the Property Law Act, which means you have the physical title and you've written a little note saying, hey, there's a covenant on it. Not you, like a lawyer has to go through and do it through the LIN system. Then that will be considered notice. Even if you're buying the property and you don't actually know, it will be considered constructive notice. So the law is construing that you knew because you should have looked at the title, or you should have got your lawyer to look at the title before you bought the land. So those are the 2 tests for covenants, whether they pass with land in relation to leased land, so from one lessor to another lessor, and owned land, so from one owner to another owner. There is also a thing called a covenant in gross, and that's in section 307A of the Property Law Act. And a covenant in gross is different. It needs to burden land, so the same as all the other covenants, but it doesn't need to benefit land. It can benefit a person. So that makes it quite a lot more flexible. A covenant in gross needs to come into effect after the 1st of January 2008, and it's binding in equity on a person who owns burden land, and you can find that rule in section 307C. Covenants in gross are very similar to encumbrance instruments, except encumbrance instruments are even more flexible because you don't need to benefit land. So it can benefit a person and burden a person. So in the court case of Menaday, the judge there said, why would any lawyer ever use a covenant in gross when you could just use an encumbrance instrument because it's so much more flexible? So that was covenants in a nutshell. If you'd like to buy my study notes on this topic, there's more information in the description below on how you can do that. Please like and subscribe, and see you next time. Bye.